Welcome. My name is Mike Villegas. I am president of iSecure Privacy. And as you can see, I'll introduce myself. But today we're going to be talking about CCPA, CPRA, the California Consumer Privacy Act. There's an update that I'd like to share with you. The last board meeting that occurred, uh, the CCPA, which is the enforcement arm of CCPA, was on September 8th. And so I'll be sharing the results of that meeting. But some of you may not be familiar with CCPA, so I'll give you an introduction, and then I'll go right into what the update is, because that's what this is about. The update on the new cybersecurity audit requirement and a risk assessment requirement. This is uh, this is me. I am not only president of my own company, but I'm also CISO at TriStar Insurance Group. It's the largest privately owned third-party administrator in the country, and I'm fortunate enough to have been there for 6 years now. I'm also CTO for a startup company, Exahive, which is a secure software, email software exchange service. There's my contact information. If at any time you want to call me, hook up with me on LinkedIn, more than happy to do so. So let's just jump right in. Um, this is the abstract of the presentation. Basically, what we're going to talk about is the California Consumer Privacy Act, but the CPPA, the California Privacy Protection Agency, which is effectively the enforcement arm of CCPA and CPRA, they have put not only together the act, but also and the addendum, but also they are there to enforce, making sure that everyone is in compliance. Enforce businesses to comply with CCPA. They met on September 8th, and I it was a grueling 8 hours that I sat through. It was a virtual session. Of course, I multitasked a little bit, but point is that there was a lot of things that were covered. Uh, on January 1st, 2023, it became enforceable. It got extended on July 1st, 2023, due to a lawsuit that was imposed on state of California Superior Court judge, delayed the enforcement of CPRA until March 29, 2024. That right now is being deliberated, but from our perspective, it's in effect, and so we need to see how how it affects us. So what we're going to do is we're going to go over an overview of CCPA and CPRA, talk a little bit about CPPA, take a look at the differences between the two, CPPA and CPRA. One does not replace the other. CPRA augments, is an extension of CCPA, so we'll need to know what those are. But then let's take a look at the requirements. And then what we're really waiting for is the cybersecurity audits that will be required of businesses that are in scope for CPPA and CPRA and CCPA, and also a risk assessment. I think I'll give you a heads up. The cybersecurity audit and the risk assessment are requiring things of us that, frankly, are beyond what I think we would have expected. And so, what I want to forewarn you is that there are things that will be asked of us that seem unreasonable and really don't give a lot of direction on how we should perform these audits and perform these risk assessments. But rightly so, it's being deliberated by the panel, by the board. So it will change. I'll show you what changed since September 8th as well, and then we'll end it with what are the penalties for noncompliance, and we'll summarize the presentation. So let me introduce CCPA. CCPA is the California Consumer Privacy Act, introduced in 2018. It's a statute that basically enhances our privacy acts as consumers and protects us for anyone that lives in California. We all know what the right to know, right to delete, right to opt out, right to non-discrimination when it comes to PII. So I need to know, what are businesses collecting about me? How can I ensure that whatever data is being collected and I want to delete it, that in fact it is being deleted, or what is not by exception being deleted. Also, do I have the right to opt out and say, I don't want you to share or sell my information to anyone unless I know about it? And also, if I do request for to opt out or the right to know, will that in fact dis, be discriminated against for any other type of services I may be asking for? The right to know is PII that's collected about you. We need to know what sources, where does the PII come from? How is the PII being used? With whom are you sharing this with? Are you selling my information, my personal information, to third parties? I need to know that. The right to request that business delete my I need to ensure that the business that collects the information PII from me, they tell me what service providers they share this with. Who are you sharing my PII with? And I have the right to ask that certain under certain exceptions that the business is legally required to keep information. If they, for example, if it's claims information, they can't pay my claims check unless they have personal information. So there are exceptions to it, but we do have the right to ask for that PII to be deleted. That's part of CCPA. Also, the right to opt out. You may request for the business to stop selling, to stop sharing personal information, and any user enabled global privacy control needs to be in place where I can opt out programmatically online, say yes or no, and selectively say what information you can share or sell, whether I give you permission or not as a business, so I can state what you can and authorize you what you can share and sell to other businesses. Or an example would be like to some firm to perform analytics on the information that I am accessing. A right to non-discriminate. Uh, the right to for non-discrimination is where I can request the business that I will not be denied any goods or services or charge a different price because I've opted out for whatever it is that I'm asking for. Some additional business obligations. The business should provide notice to consumers at or before data collection. Now that's going to be difficult because some of them are already doing it, but that's part of the law, in that you have to at or before, especially before the right to say, wait, tell me tell me what you're collecting. Also, the business is to create procedures so that I can respond to an opt out or permission for my information to be sold. There also needs to be a provision for that says "Do not sell my info" link, where I can say "Do not sell." You can use it, but don't sell it. The business also needs to respond to consumer requests from consumers to delete, and I need to know what information is being captured for me. The CCPA is almost it's in place now, but there are portions of it that are still in draft and being proposed uh, by reviewers as also the board, and so we will see some changes. Okay. Also, the business is to verify the identity of consumers who make requests. So not just anybody can request information; they have to verify that in fact it is me requesting information or some type of action on my data, and it's not anybody else but me. Some additional obligations: disclose financial incentives. Are you profiting from sharing my information? Okay. The business also needs to maintain records of any requests that have been made for 24 months, and businesses that collect, buy, or sell PII of more than 4 million consumers need to have some additional uh, uh, documentation and record keeping requirements. So that is imposed by CCPA. The opt out applies to both CCPA and CPRA. The opt-in consent for consumers under 16. For children, it needs parental control, parental permission. Need to be provided at least two methods for requesting. It could be on site on the website or a form that can be downloaded, submitted. Sometimes a phone number or an email ID is provided, but in any event, you have to at least two methods for request. The business does not need to provide a notice of right to opt out if it does not sell personal information, or if it states in its privacy policy, which the consumer will read and accept. And that's dangerous because many of us, we go through a privacy policy and we want to hurry up and scroll down to the bottom and accept. We need to know that that privacy policy may, in fact, says, "Hey, I'm selling your information, and you agreed to it, so we're good." In This is an example, and I'm not proposing that or suggesting that you use this particular vendor, but this is an example of an opt out where you accept for the cookies that are being captured for your activity. It's being used for Google Analytics or Optimize or Adobe Analytics. You are effectively saying yes, you can use it for capturing analytics on performance or on advertising, and to accept or reject either all of it or selectively suggest whatever it is that you agreed to. Okay, that's just an example. I use a different vendor, for my websites, so there's many out there. The reason I like to use vendors is because they can keep track of not just CCPA, but any other uh, United U.S. state requirements for privacy. There's 50 states, of course, and virtually every one of them has different laws, very similar, but CCPA has led the way as it usually does in California. Here's CPRA. Now, CPRA was introduced as a proposition back in November of 2020. It went into effect on January 1st, 2023. I think the important thing that you need to know about CPRA is that it amends CCPA, and it's not a separate law. In CPRA, you have the right to correct any inaccurate information, and the business needs to identify that and remediate it for you. And also, you have the right to limit the use and disclosure of sensitive information that's collected about you. So that's CPRA. It also has in the right to correct uh, the the CPPA has engaged these regulations and has enforced and rules in order to enforce CPRA. We'll go into that in just a second. For any incorrect information, and as I said, the right to limit. For example, your social security number or financial account information, GPS activity, things like that. Okay. There's no single data protection legislation in the U.S. There's no federal privacy. However, during the September 8th CPPA meeting, they kept bringing up uh, state of Colorado, and there's others that have their own privacy acts and privacy regulations and laws, but the ones in particular, California, Colorado, Connecticut, Utah, Virginia, they've all enacted comprehensive consumer data protection laws, and California, I think leads the way with CPRA, the California Privacy Rights Act, passed in November. Again, amends CCPA. Okay. Um, there, the CPRA was supposed to go into effect on July 1st. However, California Superior Court Judge James Arguelles ruled that CPRA should not go into effect until March 2024, basically stating that it has to be in effect for a year, it has to be available in a year for review, and so they rather have it on July 1st, 2020, from 2023, extended out to 24. So that file and petition uh, for delaying it, uh, there's no decision has been made. I looked everywhere before today's call, and no decision has been made. So bottom line is still effective July 1st. There's an employee exception, and this is something that we should all be aware of because CPRA eliminates CCPA's exemption for employee personal information. All employees are now subject to the same. Now, what's interesting about employees is um, I, as an employee, might say, I don't want my private information available. Well, you also don't have to work here, but there's certain there's certain factors. If you have information about yourself as an employee, there may be cases where your personal information is protected. But if you're using a company issued device, uh, I've been a CISO many years, and those laptops, those workstations, those uh, endpoints that I have given you as an employer are subject to review, and so you effectively relinquish your right to privacy because I need to scan those devices for viruses. If I have DLP, I'm looking for uh, PII, PCI, PHI, intellectual property, things that is considered critical for that company. So even though there is an employee exception, we really have to spend some time on this to find out, how does it really apply? There are some exceptions, but again, CCPA introduces the employee aspect of it. There's some key differences between CCPA and CPRA. Again, we opt out and enforcement with CCPA and also CPRA. CPRA, really, the enforcement is CPPA, the California Privacy Protection Agency, which is the meeting that we're going to elaborate in a few minutes. And then, of course, the scope. Now, it's interesting, the scope does change for CCPA. If your gross revenue is 25 million or more, or if you have 50,000 more or more consumers, you're subject to CCPA. CPRA lowers the threshold to $10 million in gross revenue for California, and that's what makes you subject and in scope for these two laws. Now, to me, this is important information. What is personal information? And I'm sorry for the background noise here. What is personal information? Uh, Identifiers such as real name, alias, uh, zip codes, and I'll let you read the rest. Commercial information, records on personal property, products, services purchased, biometric information, internet and other electronic activity, uh, browsing history, GPS, geolocation data, uh, audio, electronic, visual, thermal, olfactory, professional, employment related information, education. Now, this one, K, inferences drawn from any of the information identified in this subdivision to create a profile about a consumer reflecting the consumer's preferences, characteristics. What are your buying practices? What are you looking at? What are you browsing? Um, Things that would give me some insight on your personal characteristics, psychological trends, predispositions, attitudes, intelligence, aptitudes. That all is bundled into, in addition, since the personal information, bundled into what's called personal information. This comes straight out of CCPA. That's how it's defined. Now, CPPA, the California Privacy Protection Agency, is the enforcement arm of CPRA, CCPA and CPRA. CPPA has full administrative power, authority, and jurisdiction to implement and enforce CCPA and CPRA. If it finds a business is in violation, it can impose certain fines and restrictions. And so it has that authority through California law. We'll get into what those are. On September 8th, and I've brought this date up several times. On September 8th, CPPA and there's 5 board members, sat in a public hearing where it was televised and recorded, and I sat through the whole hearing to see what they would cover. It walked through things, changes in CPPA and CPRA, but it introduced a cybersecurity audit and a risk assessment regulation under CPRA. Now, it didn't go into a lot of detail. During that meeting, they mainly focused on what's in scope for these 2 assessments or these 2 audits, and I'll get into those changes. The CPPA still needs to formalize the rulemaking process, and it's very doubtful that they will complete the formalization and enactment of the cybersecurity audit and risk assessment, possibly even 6-9 months from now. But you need to know what it's talking about. What is it? What is it covering? So I want you to know what those are, and we'll cover that. The audit regulations requirements will be ready for the next board meeting, and which was supposed to be in November. It's now scheduled for December 8th of next month of this year, and so I'll be sitting on that, and I'll be sharing possibly through an article or something that on what the status of that is. Okay, it does go into AI. It goes to artificial intelligence. It goes into automated decision making, which are a key focus of the risk assessment, and we'll cover that as well in the next few slides. But and I also mentioned that the board members kept referencing the Colorado regs for some reason. They seem to like that one. Okay, if you look up in the upper left hand corner of your slide, it has a link where it takes you to the actual meeting notice and agenda, including the materials that were used or reviewed during the September 8th meeting. It goes back several meetings, I think over a year, so a year's worth, so you can see what those are. The most current one, which is for the December 8th meeting, is also in that link, and you can pull that down yourself and review it yourself. But the point is that in the December 8th meeting, we had the agenda, but we also had several documents that they went through in great detail. In Agenda 8, Item 8, is where they had the draft of the cybersecurity audit regulations and also the draft of the risk assessment regulations. The only thing that they'll be able to cover for today, for the December meeting is the board meeting. For December 8th board meeting is the cybersecurity audit regulation. It is already redlined, so there's some blue underlined items that are introduced new into the reg, and then anything that is in red and with as a strike through is been deleted from the original document. This is an example of what's in the cybersecurity audit. The CCPA has not fully addressed everything in the cybersecurity audit, but it does cover uh, basically an audit of an infrastructure of what we typically call general controls, and so it seems uh, pretty self-explanatory, pretty intuitive. There's some things that are a bit esoteric, which I'll get into, but the point in doing the cybersecurity audit is that when it comes to personal information, controls need to be implemented within reasonable security procedures and practices appropriate to the nature of the PII, and you'll see that in the actual document. In the cybersecurity audit, this was the original text that we saw on September 8th. This is what it looks like today. And so what I want to show you was what was stricken out. Option 2 and option 3 was stricken out. As you can see, if it has an annual gross revenue in excess of whatever it was, they took that out. but they also modified and added some additional sentences. Originally, I showed you that it was going to be 25 million from a preceding year. I think what they're proposing is that if the calendar year shows $50 million for of revenue up to 100 million dollars in the preceding calendar year, that's in scope. Uh, if it's processing personal information of 250,000, 500,000, or a million consumers or households, then what it will do is they haven't come up with that threshold yet, but that's going to be decided in the future. If it's sensitive personal information, that's also defined in the document. If it's 50, 100,000, 200,000 or more consumers, that's also defined. And then process personal information for consumers. That business's actual knowledge were less than 16 years old for individuals 16 years older or younger, then of course it's 50,000, 100,000, 200,000 consumers or less or more. So this is the change that was made for the December 8th meeting. That um, you'll see changes uh, in the actual meeting as it's going to be on December 8th, as it's going to be deliberated. Here is, and I kept this slide. I've given this presentation before, actually right after the September 8th meeting. And so I wanted to keep this slide just to show you the kinds of things they were going to be introducing. And I should probably tell you now, the five individuals on the board, all of them are extremely knowledgeable. They're well versed. They do understand security and well respected. But there's some personalities. They're all, especially two individuals, have A-type personalities, and they seem to be in conflict with each other and arguing. And I thought that was interesting. But that said, as they went over each the cybersecurity um, audit scope of who it applies to, you could tell that there's some differences of opinion. Uh, that said, now that we look at the December 8th version, they took out these things that are stricken out. But just look at what they struck out, or at least what they left, what they originally thought of. Unauthorized access or destruction, that's reasonable. I get that. Impairing consumers' control over anything that is impairing consumers' control over their personal information, okay. Economic harm, that's going to be hard to figure out, okay. But if it causes, if a negative impact of personal information being accessed, either unauthorized, is it going to cause economic harm? That that and it's impactful. That's certainly in scope. Physical harm to consumers or to property associated with the unauthorized access. I get that. But then we come into psychological harm to consumers, including emotional stress, anxiety, embarrassment, fear, frustration, shame, and feelings of violation associated with the unauthorized access, reputational harm. These are so subjective. It is, and if it's going to be a cybersecurity audit, how are they measured? How do you determine whether the controls are in place or not? And I think that's why they struck it. However, some of this is already in the body, and so we need to pay close attention to the December 8th version. Now, they only got to the cybersecurity audit; they didn't get to the risk assessment. But I will tell you that what is in the version for December 8th covers it covers obviously the title of who of the qualified individuals doing performing the responsible for cybersecurity for that entity, the date the evaluation is performed and presented to the board. But the safeguards, they sound reasonable. MFA, encryption, zero trust, account management using robust access control, employee contract, other personnel data, service provider restricted data. All that seems reasonable. Privileged accounts, inventory of PII, so that assuming that means that they're required to perform a PII. Secure hardware and software configurations. Have been half my life has been audit, and half has been cybersecurity. And invariably, as I do my assessments, their configurations errors seem to be pervasive as we run vulnerability scans, pen tests, monitoring, our own assessments. I mean, it happens. So that's reasonable. Incident response, again, that's reasonable. But when it comes to the actual PII itself, you have to wonder how in the world did they come up with this list in the first place? And is that going to be introduced later? If you're not compliant, then here's some things that were stricken out from this December 8th version. There needs to be the agency needs to receive from the business a written certification that the business complied with the requirements. It used to say during the 12 months of the audit course covers, but it doesn't say that anymore. A written acknowledgement that the business did not comply, fully comply with the requirements set forth in this article, and they have to explain why. Identify the sections, remediation time plan, written certification has to be submitted to the agency. Doesn't say when yet, and then written certification shall be signed by a member of the board. This is different also in version December 8th version. The written certification or written acknowledgement shall be signed and dated by a board member. But what they did is they added that that high-ranking executive with authority to bind and who is responsible for oversight of the business cyber audit compliance. Now that could be a CISO, that could be a security committee, if it's a governing body, it could be the board of directors. It shall include a statement that certifies that the signatory has reviewed and understands the findings of the cybersecurity audit. It's very much like PCI. I've been a QSA for was a PCI QSA for 15 years, and if you know about the payment card industry attestation of compliance, it's signed by an executive, but it's also signed by a QSA. But effectively, the executive has got some skin in the game. They're signing and basically saying that they certify that was reviewed is true and they understand the findings or the conclusion of compliance in the attestation of compliance. Here, they're saying that the signatory has reviewed and understand the findings of the security audit. So it's conceivable that there may be findings that need remediation. That is the cybersecurity audit. The next element that was introduced on September 8th was the risk assessment. Now, they haven't had time to deal with the risk assessment yet. So whatever is there stands. But let me introduce that to you, and at least you can be aware of it. The risk assessment. Every business who's processing personal information needs to present a needs to perform a risk assessment, and the operative word here is before initiating that processing. I don't. I believe that some of that processing is taking place, so the before may not be able to happen. But if you're starting off, yeah, clearly you need to perform the risk assessment before then initiating that process of collecting information. One of that PII elements is if you've got uh, information, personal information uh, uh, for adults, but also PI for less individuals less than 16 years of age. They introduce a term called automated decision making technology. Let me read it for you. Basically, it's profiling, but ADT is any system or software or process that processes personal information and uses computation as a whole or part of a system to make or execute a decision or facilitate human decision making. So basically, gathering and collecting information about an individual and running it through some type of profiling algorithm to, to know who you are. What are your buying practices? What are your characteristics? What websites, what pages did you visit? uh, and a lot of this is in order to understand you better and how we can how they can better serve you or what they can sell you. Well, that type of information is personal information. Okay, so what the risk assessment is requiring us to do is what information is that? What is the ADT process, and what are they? How are they profiling individuals? They also talk about artificial intelligence, and since September, it seems like every year it compounds. Every month, it's compounding even more every day, where we are seeing different artificial intelligence, chat GPT like sites that it will do many different things. It's almost where it's getting out of hand. But artificial intelligence means an engineered or machine based system designed to operate for different levels of autonomy and can, uh, for whatever objectives, generate outputs and predictions on what you're going to be doing. So that AI has generative models that can be used to profile an individual, but it does contain PII in the form of text, images, audio, visual, facial, speech recognition, things like that. Okay, that artificial intelligence is also included as part of the risk assessment. Excuse me. ADT, as I mentioned, AI, as I mentioned, emphasizes during the risk assessment, it needs to include language such as why does the business why does the business use AI and ADT? What are the outputs? How does it maintain the quality of information that it's capturing? And the three questions is how AI and ADT evaluates the use for validity. How valid is the information? How reliable is information? How fair is the information? That all has to be done by someone either in the business entity to perform that risk assessment, or you hire somebody else to do it. That risk assessment needs to be performed at least once every 3 years for a business to review and to perform. Uh, that's option one. Option two is that it needs to be performed at least annually, biannually, or once every 3 years. These are, again, options. They have not been decided yet. Now, what are the penalties for noncompliance? Any entity that violates CPRA can face an injunction and an administrative fine of up to $2,500 per violation. For violation on the rights of minors, if the minor, if the individual is under the age of 16, the fine can be up to $7,500 for each violation. CPRA eliminates the 30-day cure period after the alleged violation or CPA, and and then CPRA expands the scope of the consumer's rights to include data breaches involving email account credentials, which is interesting. If you're looking at this, and if you're a privacy cybersecurity professional, become familiar with the breach notification laws, the uh, the number of consumers or account number thresholds for each state. Like in California, it's 500, and also how many days do you have before reporting it to the state attorney general for that respective state. So we've covered a lot, and I've gone through this initially just to introduce you to CCPA and CPRA, and also to basically give you an idea of what the requirements are. But the focus really was to introduce you to these two the audit and the risk assessment. On December 8th, there will be a new meeting for the board, the CPPA board, and we will get a better feel for where this is going. Uh, but regardless, uh, Should we still comply with CCPA? Absolutely. It's in effect now. It is in effect now, and so we need to abide by it. We need to ensure that we have a CCPA, CPRA privacy policy on our websites. That we have all of our websites have the ability to, or have the opt out capability, at least in two forms. We need to manage our cookies so that it will provide the opt out privilege for those logging onto your website to accept the cookies or not. There are certain cookies that are required in order to provide services, but there are cookies that might contain PII where you can opt out during your web session. I've shared as much as I could with you. I hopefully this is a great help to you. I want to thank you very much for your attention, and we look forward to speaking with you again.